Hello everyone, this is Advocate Dr. Sheetal Babar, and in this session we shall be discussing about one more doctrine under Transfer of Property Act, and that is doctrine of part performance. In my earlier two sessions I have already discussed doctrine of election as well as doctrine of estoppel. Now this is the third session which we shall be focusing on doctrine of part performance in the series of doctrines under Transfer of Property Act. Now, when I say doctrine of part performance, again from the nomenclature, we understand that someone has partly performed or is ready to partly perform his part of the contract. And this seems to be something which we say an equity or an occasion to create an equilibrium in between the one who has contracted, the one who has performed, and the rights of the contractor as well as the performer. Now, this is all the layman language. Where do we find this doctrine of part performance under Transfer of Property Act? We find this doctrine of part performance under Transfer of Property Act underneath Section 53A. Section 53A discusses everything about the part performance or doctrine of part performance. To understand this doctrine of part performance, we need first, as usual, to read the section, then find the essentials and take a support from the landmark judgments to understand this doctrine. So let us go with our very first step or stage to read this section 53A. As per section 53A, where any person contracts to transfer for consideration any immovable property by writing signed by him or on his behalf from anyone else on his behalf, from which the terms necessary to constitute the transfer can be ascertained with reasonable certainty, and the transferee has in part performance of the contract taken possession of the property or any part thereof, or the transferee being already in possession continues in possession in part performance of the contract and has done some act in furtherance of the contract, and the transferee has performed or is willing to perform his part of the contract. Then, notwithstanding that where there is an instrument of transfer, that transfer had not been completed in the manner prescribed, therefore by the law for time being in force, the transferor or any person claiming under him shall be debarred from enforcing against the transferee and persons claiming under him any right in respect of the property of which the transferee has taken or continued in possession, other than a right expressly provided by the terms of the contract, provided that nothing in this section shall affect the rights of the transferee for consideration who has no notice of the contract of part performance thereof. A huge section, I must say. So many words, so many interpretations. Let us go one by one as to what exactly these all words constitutes and what these all words interpret when it comes to equity. Because as I again and again state, so when it comes to Transfer of Property Act, mostly the whole act is based on principle of equity, and whenever I deal with any of the doctrines, they definitely are based on this principle or they have a foundation of this principle of equity. So let us see basically what all essentials does this particular section speaks about. Now, to understand the essentials of this particular section, I shall be taking a support of very landmark and old judgment on which the whole basis of the section 53 has been interpreted or has been based upon, has a foundation upon. It is Nathulal versus Fulchand. This is the case which gives us 6 criteria or essentials or requisites to talk about, interpret and understand section 53. Let us see these essentials and then let us go up to the elaboration of all of these. The first essential of section 53A as per Nathulal's case is there must be a contract to transfer for consideration any immovable property. So in the very first essential, we actually have 3 sub-essentials. What are those? First, there has to be a contract. That means there has to be a proposal, offer, acceptance. And secondly, there has to be a consideration, because unless and until it is for consideration, we don't take it as a contract. So there has to be an agreement in between the parties, which is a lawful agreement rather, or an agreement with a lawful object, and all of those essentials for a particular contract. So there has to be a contract. For what? A contract to transfer for consideration and of immovable property. So contract to transfer for consideration and immovable property are 3 essentials of the very first essential of section 53A. Secondly, which is most important to understand and which is most important mandate put under section 53, second requisite is contract must be in writing, signed by the transferor or by someone on his behalf. So see, if we compare this particular essential with the English law, we might skip this part. But under Indian, specifically Doctrine of Part Performance, this needs to be in writing and appropriately signed, I say. And why do I say so appropriately signed? Because it can be signed by the transferor himself, or on behalf of him, anyone else can put a signature on that particular document, which needs to be in writing. So now we have 2 requisites. First one is there has to be a contract which is of transfer for consideration and of an immovable property. Secondly, this contract should be or must be in writing and signed by the transferor or anyone on his behalf. Thirdly, this writing is not only the essential, but we go ahead as per section 53 and we state, or rather this section states, that this writing should be the one which gives certain or rather certainty or clarity to the terms which are put up under this contract. So ambiguous writing is non-acceptable under section 53A. It states as to third essential, the writing of this contract must be clear or must give us a clarity when it comes to terms or interpreting or understanding the terms of the contract, which is in writing, signed by the transferor or anyone on his behalf for consideration of immovable property. Let's go ahead. The fourth essential, which is put up by Nathulal's case, is transferee must in part performance of the contract take possession of the property or of any part thereof. Now, it is quite clear that section 53A speaks only about immovable property. And when we're talking about now the transferee's role, fourth essential states that transferee shall have the possession of the property and not necessarily the whole possession of the property. It can be a part possession or he can possess the property partly also. So your constructive possession can also be a part. If you're talking about, for example, a flat, which is immovable property, just for an illustration. The keys, original keys of the flat in possession of the transferee is to be considered as possession by the transferee. Fifthly, the transferee must have done some act in furtherance of the contract. So in our illustration, if it is a flat which is immovable property, the original keys with the transferee, then some act in furtherance of this contract he must have done. Say for example, he monthly or weekly visits the flats, cleans it up, or resides or stays there for a night or two. Not necessarily residing or staying in the flat is must, but maintenance of that flat is a prima facie or apparent proof, which we say, wherein he is doing something in furtherance or doing some act in furtherance of the contract. And lastly, the transferee must have performed or be willing to perform his part of the contract. So say for example, the transferee has paid a certain amount, not the whole amount. He's maintaining the flat, he's visiting the flat, he's residing for a while in the flat once or twice a month or a year. In this case, he now is ready to pay the remaining amount. So see, if we calculate the whole essentials, the first one is there needs to be a contract. Secondly, contract should be for consideration. Thirdly, contract needs to be regarding some immovable property. Fourthly, it needs to be in writing. Fifthly, it needs to be signed by the transferor or anyone on his behalf. Sixthly, this writing should be with clarity to understand the terms of the contract. This is what transferor's part. Seventh onwards requisite we say are all about the transferee's role. Firstly, the transferee must impart performance to any act which I say gives or puts up his desire to go in furtherance of this contract. Secondly, he must have done something to take the possession of that immovable property. So as in I said, he just have the keys of the flat is all sufficient to state that he has possession of the flat. And finally, he must have performed or be willing to perform his part of the contract. That means, say for example, a payment I would say is the simplest example of both of these situations, that he has performed something and he is willing to perform the remaining part of his role. So these are all requisites of section 53, that is part performance. Now, what does section 53 upon all of these requisites help or support, and to whom? Basically, section 53A or doctrine of part performance is more supportive to the transferee. And that is why basically the requisite, half of them talk about the transferor and half of them talk about the transferee. But this is the best defense for the transferee, because if he has done anything in furtherance, he's taken the possession and done anything in furtherance to perform this contract, or is willing to perform his remaining part of the contract, then he cannot be assailed out of the possession of the property which he is desiring or willing to buy, purchase, or take wholly into possession, because this is for consideration. So transferor here has put up, or by section 53 is been stopped by taking excuse or claiming any right over the property where transferee has played his role. Hence, part performance plays a vital role when it comes to a contract of immovable property, and especially only when it is for consideration. So section 53A under part performance or doctrine of part performance gives an equilibrium. The transferor has written something and signed. That means he was desirous or he was willing to transfer this property to the transferee. That means at the very instance of this contract for consideration for immovable property, transferor has apparently, or rather by putting his signatures onto the document, has given all his intention clearly. Secondly, in furtherance to that, he has also given possession to the transferee. Transferee has taken the possession. Transferee is using that property. Transferee is utilizing that property. Transferee is willing to perform or has already performed some part of his role. At this very point, transferor cannot back out. That is what the exact defense available to the transferee under doctrine of part performance. But then, doctrine of part performance is only a defense for the transferee to receive the property after performing the remaining role of his. Section 53 definitely does not give any right of ownership to the transferee. Rather, it supports or it helps the transferee to receive the property because he has played his role and willing to play his role, remaining or residuary role, to complete this contract. This is what all about section 53A and doctrine of part performance under Transfer of Property Act. Thank you so much.